Defendant was last before Your Honor on November 25th of 2025, where he pled guilty by way of information to all 5 cases. 1450, pled guilty to grand theft of a motor vehicle, found in the 4th degree, and theft found in the 5th degree. 1570, pled guilty to grand theft of a motor vehicle, found in the 4th degree, and misuse of credit cards, found in the 5th degree. The remaining 3 cases, 1571, 1572, 1573, were all 1 count of grand theft of a motor vehicle, found in the 4th degree. At that time, a pre-sentence report, psychological evaluation, and victim impact statements were ordered. It's the state's understanding that the report and evaluations were completed and provided to the court, and that approximately 4 victim impact statements were received by the court as well, and that all parties were prepared to go to sentencing at this time. Thank you.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I don't know what to say, Your Honor, in this case. This is kind of a first for me. This is a young man who I think still has his whole life ahead of him, and got himself into a world of trouble, and not only here in Lake County, but in other counties too. I know the court's well aware that he was already on probation, I believe out of Cuyahoga County, when he went on his little crime spree here in Lake County, and got picked up. Has been sitting in our county jail for almost 3 months now, and I know that there's still pending charges, and I believe Cuyahoga County and I believe Portage County. So Mr. Hudson has certainly dug himself a very deep hole at a young age. I can say, Your Honor, ever since I met him, I think he's actually a good person, and I know that this doesn't, why he's before this court does not reflect that at all, and I know this court probably has no reason to believe that, but I've talked to him numerous times. He is very remorseful for what he did. He wants to try to make it right. He was cooperative with the police departments, various police departments, when they came and talked to him. He's told me since the beginning that he's done. He's through with doing what he's been doing. And the reason he did it, now, I know that there was a little bit of a difference of opinion in chambers on this, but Mr. Hudson told me that he was homeless at the time, and not that that's an excuse or to justify what he did, but he was homeless and he was out doing what he had to do, according to him.
That's not what he told probation.
I'm sorry.
It's not what he told probation.
Well, again, Your Honor, I know that's why I specified that there's a difference there. But with respect to the court, Your Honor, I know Mr. Hudson's got a lot of time ahead of him with these 5 different cases. I know the court today can do a lot of different things when it comes to sentencing. I'm simply going to ask the court to just look at the fact that he's still a young man. He just turned, I believe, 22. He still has the potential to turn his life around and do a lot of good. He's expressed to me he wants to do that. I believe he wants to do that and will do that. I'm hoping the court will take these factors into consideration. I know in chambers I had asked the court to consider either community control sanction or on a lower end sentence. And I normally wouldn't even ask for a community control sanction on a case like this, had it not be for his age and for the fact that he's cooperative. And again, at least with me, he's been very remorseful with his actions, and he does want to make a change, Your Honor. But if the court doesn't feel that that's appropriate, I'm just asking the court again to consider the fact that he is a young man. He still has his whole life ahead of him, and I just hope the court considers that. Thank you, Your Honor.
Mr. Hudson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
No, sir.
Mr. Watson, anything else?
Just that, Your Honor, I actually want to just quickly add, my client was actually going to say something, and then right after I came out of chambers, and I had told him the state's recommendation, he opted to say nothing, and I just wanted to let the court know that I think it's because he's given up. He's just throwing.
Well, you're speculating here. You can do whatever you want. You can say whatever you want, I guess.
I may be speculating, Your Honor, but
I'm not speaking.
Okay, I know.
I'm not going to consider the fact that he was going to speak. He's not speaking.
Okay,
he doesn't have to speak. He has a right to. He doesn't have to, and I don't. hold that against him if he doesn't want to say anything, but
Okay.
I'm not going to take into consideration that he was planning on speaking. I mean,
No, I was letting the court know, I think he's thrown in the towel, but that's all, Your Honor. Thank you.
cuts for the state of Ohio.
Thank you, Your Honor. Before I address the court, I would ask, Mr. Costello is here. He's from case 25 CR 1572. He would like to address the court.
Mr. Costello, you could just stand right where you're, state your full name, please, to the court reporter, and then spell your last name. I think we probably figured that out, but spell it anyway, and then
Joseph Costello. Look at me, Costello. Costello.
Go ahead, take your time and say whatever you'd like me to know.
Okay. Can I address Mr. Hudson?
You can say whatever you'd like, yeah.
So, Mr. Hudson, I know you may or may not listen to what I have to say, but it's hard to be a man. And our decisions have brought us to where we are, and unfortunately, your decisions have brought you here. I never expected to have my car stolen and for it to affect my life the way it did. But I look at that seal behind the judge that says, with God, all things are possible. And I do pray that after this experience, after you go through whatever it is that the judge hands down, that you find a new path, man. That, even though you're young, like, you got the rest of your life ahead of you. Like, yes, it sounds like you may be in for a while. I'm not quite sure, but I do pray that, that when this season of your life is over, you got family over here that sounds like they love you, and sounds like you got a young daughter who also loves you in your life. So I pray that, man, you go through this season of your life, and the next season of your life, you make better choices. I do believe in paying for what he's done. We all got to stand up and take what's coming to us, but I do pray that, man, you turn this around eventually. 22 years old is not the way to start this off.
Thank you, Mr. Costello, very much. Ms. Cuts for the state of Ohio.
Thank you, Your Honor. These cases encompass 5 different jurisdictions from August 2nd to October 1st of 2025. Having affected 5 people with their cars being taken, an additional person with a credit card being taken out of the car. So we have Wickliffe, Eastlake, Willoughby Hills, Willoughby, and Menor Police Department. It starts with Mr. Costello's car on August 2nd. That's the 1572 case. His car was recovered. Thankfully, it was not damaged. It needed to be aired out. Keys were no longer there. So insurance did cover a large portion. However, Mr. Costello did have to cover his deductible of $250. On August 31st, in Eastlake Police Department, Mr. Dolan's vehicle was taken. That car was recovered by Akron Police Department with no new damage. However, it had to be towed. There was a cell phone in the car, some other things that had to be dealt with. After insurance, Mr. Dolan had to pay $500 out of pocket. September 20th, in Willoughby Hills, Mr. Boyd's vehicle was taken. It was recovered about a week later by Cleveland Police Department. That his vehicle was totaled. It was recovered because there was an accident at an intersection where the defendant was driving the stolen truck. He left on foot after the accident, and a female was taken to the hospital. I don't have the details of some of that because it was in another jurisdiction, but that is the information I received. Mr. Boyd indicated to me that insurance totaled his car and that he had a deductible of $250.
Did you say that was September 20th?
The vehicle was taken, I believe, September 20th.
You have September 2nd. I don't know which one you transpose numbers.
That's 1571. Then September 29th, in Willoughby, Miss Bostick's vehicle was taken. That car was eventually recovered in Garfield Heights. Garfield Heights became aware of the vehicle in their community, I believe through Flock, that it was a stolen vehicle. They went to do a traffic stop. The defendant fled from the police, high-speed chase. He struck a pole that broke, took another pole down. They had to shut the street down to fix that. The car rolled. Thankfully, the defendant was not injured. He was the only one in the car. The police informed me that they were very concerned. If he had not hit the pole, he would have gone into a house that had an elderly female in it. Garfield Heights did arrest him at that point, and that case there's a warrant out in that case. And then October 1st, a car was taken from Menor Menor.
So he bonded out, obviously, then on the September 20th one?
He was arrested October 3rd.
Oh, I gotcha. Right.
On October 1st is the Menor. The vehicle was stolen outside Miss Carney's work. It was recovered that same day by Cleveland, thankfully without damage. In that case, her credit cards had actually been taken, and 4 credit cards were used for over $1,000 worth. She did get that back, but obviously the banks are out. Another case that was put into 1450 dealt with Anthony Tortorici. His car was not stolen, but while he was parked at Heinen's, the defendant went into his vehicle and took a credit card, went to Walgreens, and spent just under $40 on a gift card. He was also reimbursed by his bank, but they are out that money. So this was a long, continuous occurrence in Lake County. We are aware that there were Cuyahoga County and Portage County issues as well, which I will get to. But just in the seriousness of this case, there was obviously taking people's property, damaging it, other people being injured or affected, and damage to property. So this was an extensive incident that was going approximately 2 months in Lake County alone. And all of these individuals were negatively affected, some more than others, but none of them deserve to have their vehicles taken. Defendant has been in the jail since October 3rd. However, he is serving a Willoughby Municipal Court sentence from Willoughby Hills Police Department, where there was a theft of, my recollection is, a bag that had electronics in it and things of that nature. So he has no credit in any of these cases based on that and the fact that some of them were secrets that he wasn't booked in until he came to this court. So we have the economic harm, some of the psychological harm from having your items taken or people being in your vehicle without permission. Some of the individuals had things in their cars that could identify where they live or where they work, which always adds a level of concern. I have at least one individual who changed their locks at their home because their house keys were on there, and just concerns of work keys and if anything could happen to that. So there's a whole level that goes beyond having one item taken. In addition to that, the defendant does have a history of criminal convictions. He mentions in 2022 a breaking and entering. I don't know if that was confirmed. In 2024, he has a conviction for misdemeanor theft. In 2025, he has convictions for unauthorized use of a vehicle, misdemeanor of the first degree, which he currently has a warrant out for. Grand theft of a motor vehicle found in the 5th degree, she was on probation for, and then theft, misdemeanor of the first degree. She's put on probation in both of those cases where they occurred in September, while most of these were going on. He has warrants for failure to appear from Portage County Municipal Court in Kent. He has a warrant for Orange Village for grand theft of a motor vehicle, which the state's understanding is another vehicle that was stolen outside of our county, I believe prior to some of these incidents that involved threats to the actual car owner. There's a warrant out of Garfield Heights Police Department for failing to fly, vandalism, and receiving stolen property, which goes to the vehicle that was totaled in 1450. And then it appears he missed an arraignment on a burglary, theft, and identity fraud case. He has had issues while he's been in the jail. There have been some serious violations based on the terminology of the jail. In October, an assault on an inmate. In November, an assault on an inmate, and also threats in November. He was on probation for at least 3 of these cases when they occurred and was at least on bond on that case prior to putting on probation on the other 2. Prison is clearly consistent. The question is whether he is amenable. The court is concerned that there wouldn't be things that would help him at this point. He has indicated that he knew it was wrong, he knows it is wrong, he knows he should stop and not do it. He indicated that He knows to leave other people's stuff alone before I steal from the wrong person, which seems to imply more of a concern of if somebody is violent with him, then that he should not do it. He did have opportunities in his home. Obviously, the loss of a parent is always difficult, but it doesn't make it okay to steal from other people and create more issues in their lives as well. So we do feel the prison is consistent. He has 0 credit. We would ask for the restitution to be ordered in each case. And that we feel consecutive sentences would be appropriate based on the multiple courses of conduct, multiple victims, being on probation for bond. And that would be the state's recommendation at this time.
Thank you. This court reviewed the pre-sentence report, an investigation, psychological evaluation. I've read all the victim impact statements I received from all the cases. I've considered the facts and circumstances of the offenses, the nature of the offenses. And I've considered everything that's been said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, the court notes that in each of these cases, the victims suffered serious economic harm and psychological harm. Some of the victim impact statements detail what these folks are still experiencing, the stress that they're experiencing. It also talks about what they have to go through. Yeah, sure, they lost property that could be replaced perhaps, but the inconvenience, the time you have to spend to cancel all your credit cards, the time sitting on a phone, the time having to replace everything, it's hours and hours and hours. And these people shouldn't have to deal with all that. And they had to. So again, the economic harm as well as the psychological harm. No factors indicate that the offense is less serious. You know, his age or youth certainly doesn't change the impact his conduct had on the victims and on our community and society. It's not less of an impact because he's only 22. They still experienced and had to suffer what they suffered. That doesn't make it less serious. As for recidivism factors, the court notes the defendant does have a history of criminal convictions, even though he's only just turned 22. He's got multiple warrants out for him right now for similar type of conduct in other counties. He was on probation for 2 different cases at the time he committed the offense. Literally put on probation September 3rd, and he's committing an offense within a couple weeks later. Same type of stuff, multiple offenses. So he says he knows stealing is wrong, but gets put on probation for it and just continues doing it. Also, in regards to these offenses, while the conduct didn't occur in Lake County, these stolen cars he's driving, he's ultimately driving them in high-speed chases with police officers. He's causing damage to people. He's causing damage to property. And fleeing from police and trying to get away with it. I had noted the same thing the prosecutor noted when he was talking about what he has learned. His comment is, I know now to leave other people's stuff alone before I steal from the wrong person. There's no genuine remorse. No factors indicate recidivism is less likely. Under 29-13B1, the court notes that the defendant was on probation to Cuyahoga County in 2 cases when he committed the offenses in 1450, 1570, and 1571. Prison is certainly consistent with the purposes and principles of sentencing. And when you look at the nature of the conduct involved here, I certainly take issue with the characterization of that he was on this little crime spree. I mean, he's a walking, talking, breathing crime spree that just still continues on. Even after he gets caught and arrested and put on probation, he just gets right back up on the horse and continues doing the same stuff. And it's not amenable to community control sanctions, and quite frankly, the spree that he went on and the conduct he engaged in over and over and over and over and over deserves prison terms. Therefore, it'll be the sentence of this court that in case 25 CR 1450, defendant serve a term in prison on count 1, 24 months, and count 2 of 11 months. I'll run those two counts concurrent with each other.
Your Honor, what on count 1?
24 months on count 1.
24?
Oh, wait, I'm sorry. It's an F4. 18 months on count 1. 11 months on... Let me change this. I'm sorry. I'll start over. We do 17 months on count 1. 11 months on count 2. Those will be concurrent with each other. It's going to be restitution to Mr. Bostic in the amount of $1,350 and to Fifth Third Bank in the amount of $38.95. Case 25 CR 1570. So sentence of the court, then count 1. Then serve a term in prison of 17 months. And count 2, 11 months. I'll run those two terms concurrent with each other, but consecutive to the prison term imposed in 25 CR 1450. Defendant's ordered to pay restitution to Chase Bank in the amount of $212. To Bank of America in the amount of $319.95. To Capital One in the amount of $415.90. And American Express in the amount of $346.90. Case 25 CR 1571 is the sentence of the court. Defendant serve a term in prison of 17 months. They'll be concurrent to the terms imposed in the first two cases, 1450 and 1570. Restitution in this case to Mr. Boyd in the amount of $250. Case 25 CR 1572 is the sentence of the court. Defendant serve a term in prison of 17 months. They'll be concurrent to the previously imposed terms, prison terms. Restitution to Mr. Costello in the amount of $250. In case 25 CR 1573, then shall serve a term in prison of 17 months and be served concurrent with the previously imposed terms. Restitution to Mr. Dolan in the amount of $500. There's no credit for any time served in any of these cases, as the defendant was serving a jail sentence on an unrelated case at the same time he was in jail in this case, in any of these cases. So it's a total of 34 months in prison. Defendant's ordered to pay all costs incurred in all these actions. Need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months. For each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. For further fines, consecutive service is necessary to protect the public from future crime or to punish the offender.
Thanks for watching. If you follow real courtroom cases like this, leave your thoughts in the comments and subscribe for more authentic court proceedings.